Welcome back. We're now going to discuss the second lecture on affirmative action, what happened after the Bakke decision. And if you'll recall from earlier lecture, in the case of the University of California against Alan Bakke, the Supreme Court, in a very divided, complex decision, ends up deciding that you could use race as a factor in college admissions and other things that involved federally supported institutions, but you couldn't use quotas. And the court said that the only justification for using race as a factor in admissions was that it had educational benefits for the entire student body, that there was a benefit to having a diverse student body. Well, ever since Bakke, there have been a range of cases that have whittled away at Bakke, reinforced Bakke, and made the whole thing a little bit more confusing. However, as we'll see, in each one of these cases, you pretty much end up preserving, at least for the time being, the fact that race can be used as some form of consideration in admissions, but there can't be rigid quotas, and it has to be done in a carefully and narrowly tailored manner. The backlash against the Bakke decision, to some extent, begins with this guy, Ward Connolly. He happens to be from Louisiana, from Leesville, Louisiana, and he self-identified as multiracial. He was half white, 1/4 black, and 1/4, he said, everything from Choctaw Indians to various Louisiana mix, as you might have it. But he grew up identifying himself as part of the African-American community, moves out to California, and gets appointed to the board of the University of California, the Board of Regents, in 1993. And he starts looking at the race considerations that came after the Bakke decision, and he decides that racial factors just violate his sense of ethics and morality, and also, in his mind, violates the Constitution of the United States and the Civil Rights Act. So he begins to push that they abolish race and use economic considerations instead. And so you have Proposition 209, which was passed in November of 1996, with Ward Connolly being one of the driving forces. In California, you can put on the ballot a proposition that the voters get to vote on. And Proposition 209 was pretty simple. It said, and it kind of echoes the Civil Rights Act of 1964 with these words, it says, "The state shall not discriminate against or grant preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or national origins in the operation of public employment, public education, or public contracting." So that passes in California with about 55% of the vote. And thus it eliminates the overt use of race as a consideration in the admissions in the University of California system. Then we get to a case in Texas called Hopwood versus Texas. It's about a young woman named Cheryl Hopwood who applied to the University of Texas Law School. She was, once again, one of these plaintiffs that has a very good personal story. She was a military wife. She was the mother of a child with developmental disabilities. So she stayed at home, but was able to do very well in college and wanted to get admitted to the University of Texas Law School. The University of Texas Law School had a dual admissions process, a little bit like the one in California before Bakke, but it was more carefully tailored to meet the constitutional demands. And out of those dual admissions system, it admitted 62 African Americans, 53 of whom had lower scores than Cheryl Hopwood. So she sued. The district court follows Bakke. It strikes down the dual track system, but says that the University of Texas can still consider race. And the judge says that it's regrettable that affirmative action programs are still needed in our society, but they are until we are able to overcome the legacy of institutional racism. However, it goes to the Fifth Circuit Court of Appeals based here in New Orleans, and Judge Jerry Smith, that's the person pictured on this slide, strikes down racial preferences totally, strikes down the University of Texas system, and says, within the general principles of the 14th Amendment, the use of race in admissions for diversity in higher education contradicts rather than furthers the aims of equal protection. Now, that's confusing because the Supreme Court seemed to have allowed that in Bakke. The Supreme Court decides to duck this case. It doesn't take it on the theory that, well, the state was no longer following those exact same guidelines. Basically, they wanted to get a better case and wait until they had to decide this again. And in the meantime, Texas adopts a plan that just allows the top 10% of its graduating high school students to get into the University of Texas Law School. That helps promote diversity because it means from every different public school in the state, the top 10% are going to be admitted. The Supreme Court finally takes on the cases, not by picking up the Texas case on appeal from the Fifth Circuit, but by taking two cases out of Michigan. This is in 2003, and we have Sandra Day O'Connor as the justice who's taken over the seat of Lewis Powell, and she's the swing vote. She's able to cobble together majorities on most occasions by enlisting some of the liberals or some of the four conservatives. And she's able to be the swing vote in these affirmative action cases of 2003. There are two of them from the University of Michigan that come up. And so what they do is they split the difference. In the Michigan case of Gratz v. Bollinger, they declared it was unconstitutional, a system that automatically awarded 20 points out of a possible 100. In other words, the admissions process for the undergraduate admissions at University of Michigan had a 100-point scoring system, and some were based on grades, some were based on SATs, but 20 of the points were based on the fact that if you were part of one of three racial groups, African Americans, Hispanics, or Native Americans. And Sandra Day O'Connor ruled that that just was not narrowly tailored. The object of being narrowly tailored is you can't just use some broad system to give racial preferences. But if you're going to do it, it has to be for a very specific reason and very narrowly tailored. And just blanketly giving 20 points because of race was, in her mind, and then, of course, the court's mind, because she writes a ruling opinion, not constitutionally justifiable. However, there's another case, which is the case of Gupter versus Bollinger. And this was for the law school. And in this case, Sandra Day O'Connor voted that you could take affirmative action into account. These cases were decided at the same time. So it was a way to create this balance, to almost try to find the middle ground. And she upheld the way the law school did it because it takes race into account on an individual basis. It doesn't award 20 points. It doesn't automatically give a special track to people because of their race. But it just says, in looking at the entire applicant holistically, judging all the factors about an applicant, you can take race into account when you're judging how persistent or how much grit or how much promise a particular applicant has. You can look at their background and say, including because of their race, they have this particularly strong case to be admitted. And she writes that the Constitution does not prohibit the law school's narrowly tailored, that's an important word, use of race in admissions decisions to further a compelling interest. In other words, the state has a compelling interest which allows it to overcome the presumption of equal protection without regard to race. And that compelling interest is in obtaining the educational benefits that flow from a diverse student body. Okay, I want you to think about that for a moment. You're in a place that has a diverse student body. Are there educational benefits? Is that a compelling interest of government to say, yes, it's important to have those educational benefits that come from diversity, from reflecting all of our society, from training people at an institution, educating them at an institution that reflects the rest of society, because they're going to have to deal with the rest of society once they graduate. And she also added something unusual for a Supreme Court decision. It said probably in 25 years, affirmative action wouldn't be necessary, that this isn't permanent in our society. Once we overcome the legacies of racism, we'll have enough diversity that you won't need affirmative action. Well, that was in 2003, and people said, well, we better start working on overcoming racial inequalities so that by the time we get from 25 years, we can end affirmative action. We're now getting close. That's 2028. We can almost see the class that'll be admitted in 2028. And you be the judge on whether or not we're close enough to having racial equality that will no longer need affirmative action in order to have the type of diverse student body that the court said is important for the compelling state interest, the compelling government interest that can be used to say that that's compelling enough that we will overcome the constitutional presumption that we don't make any preferences based on race. Once again, Texas comes up. It finally gets a case to the Supreme Court. As I said, the earlier Supreme Court case of Hopwood, if you remember Hopwood, we talked about it a moment ago. Hopwood is decided by the Fifth Circuit, but it's not appealed. It doesn't get accepted by the Supreme Court. And in Hopwood, the Fifth Circuit Court of Appeals just struck down any racial preferences that were granted, struck down University of Texas, giving any consideration based on race. That flies in the face of what the Supreme Court has said in the Michigan cases. So finally, after the Michigan cases, the Supreme Court takes up a Texas case to decide that. Texas had that top 10% rule that said if you're in the top 10%, you get in. It also said holistically, even for the others that were considering admissions to, we will consider race as a factor as we look at a student holistically and see what that student's background brings to the possibility of being in the law school. Abigail Fisher was not in the top 10% of her class. She went to Stephen F. Austin, a really great high school, but she was in the top 12%, and she doesn't get admitted even though her test scores are good. She has a lot of extracurriculars, and she sues based on that. In the Supreme Court argument, you have the late Justice Antonin Scalia, and he asked a very controversial question from the bench during the oral arguments. That very controversial question, one that we, has been debated, but is generally one that is extremely controversial to deal with. He says, there are those who contend that it doesn't benefit African Americans to get them into the University of Texas, where they won't do well, as opposed to having them go to a less advanced school, a lower track school, where they might do well. Well, that, of course, causes an uproar. what happens is he doesn't end up voting on the case, Justice Scalia, because he dies before the case is decided. Elena Kagan, who had just been appointed to the court, recused herself because as Solicitor General, she had argued this case. So it's decided by 4-3 vote with Anthony Kennedy playing sort of the swing vote, the moderate in the middle. And he writes that universities may use race as part of a holistic admissions program where it cannot otherwise achieve diversity. The goals that the court affirmed, why would you have a diversity? And what is a compelling state interest? And in his decision, he said, those goals that are legitimate include the destruction of stereotypes, the promotion of cross-racial understanding. In other words, even if you're not Black and you're a white person admitted to the university, you benefit from affirmative action because it promotes cross-racial understanding. You also benefit because it prepares students for an increasingly diverse workforce and society, and it cultivates people of all races for being leaders with the legitimacy in the eyes of their citizenry. So think about it. Even if you're not the benefit of affirmative action in terms of you being Black or a minority that benefits, do you benefit still from being part of a system that promotes cross-racial understanding and allows you to be well-trained for an increasingly diverse workplace? Well, Justice Clarence Thomas dissented. He's the only African-American. He dissents as an African-American justice, a conservative African-American justice, and simply says a state's use of race in higher education admissions decisions is categorically prohibited by the Equal Protection Clause. The latest case, it's still in process, it's not even reached the appeals court level yet, is the Students for Fair Admissions versus Harvard, run by a guy named, it was brought by a guy named Edward Bloom. You see him in the picture. He's an activist against affirmative action. He's somebody who has always fought it as a conservative. And in this case, he did it putatively, or he says on behalf of Asian Americans, because if you give benefits to African Americans, it means fewer Asian Americans are going to be admitted. And he says Asian Americans, they have high test scores, they would be admitted in higher numbers. But once you give affirmative action, they get discriminated against because of their race. And he compares it to the way in the 1920s, 30s, and 40s under A. Lawrence Lowell and others at Harvard, there was an admission quota system that restricted the number of Jews. Jewish students scored very well on tests, but Harvard had a holistic system, gave preferences to legacies, people whose parents or grandparents had gone to Harvard, to donors and others, and it restricted the number of Jews. Edward Bloom says, and the people who are fighting Harvard say, that that's what's happening to Asians now. It's an unusual case. It would mean the absolute reversal of Bakke if the Supreme Court decides for the plaintiffs in this case, because Bakke in 1978 specifically cited the Harvard admissions procedure as a good example, and it puts it in the Bakke decision. This is a good example of, as Justice Lewis Powell, in writing in the Bakke decision, says, this is how it's supposed to be done, a holistic system that maybe considers race as part of an overall judging of what a student brings. In 2019, the federal judge rules in favor of Harvard, saying that it's doing just fine on that. However, it's appealed, and at the moment, it's still on appeal and probably or may get to the Supreme Court. We shall see. Back in California, you have the case of trying to eliminate Proposition 209. That was the one we discussed that says you can't use race in any way, shape, or form in the admissions procedures of the University of California. So the University of California, after Proposition 209 was passed in 1996, they do something similar to Texas. They say we'll admit the top 4% of any high school class. That does help to some extent, not to a full extent. It does help increase diversity at the University of California, 14 major university campuses. It also says that besides admitting the top 4% of the class, we're going to use a holistic system like the Harvard system. We're going to look at 14 factors that include test scores, grades, recommendations, but also among those 14 factors are the opportunities that you had in your background, the opportunities you grew up with, which to some extent includes the question of race. In June of 2020, recently, the University of California Regents decided to go whole hog and to say, let's get rid of Proposition 209. That was put on the California ballot for vote in November of 2020. And the head of the Regents, John Perez, said a colorblind model for society denies the reality of racism. So they are fighting to get rid of Prop 209, and they're fighting to go back to a system where they can consider race directly rather than in this indirect way it's now being used. And in addition, they voted to phase out the SAT and ACT test scores, saying that those are racially discriminatory based on the opportunities and income and education of parents, and getting rid of standardized tests was done partly in order to increase diversity. I'm going to end by giving the last word to Janet Napolitano, who's the 20th president of the University of California, and in the year 2020 led the fight to get rid of Proposition 209 and to have race be considered as a form of admissions. For a show I do on PBS called Amanpour and Company, I interviewed Janet Napolitano in July of 2020 as coronavirus was sweeping the University of California. And I asked her about why would you want race to be considered in the admissions policies of the University of California. So let's listen to what she has to say. You and others at the University of California have now endorsed a proposition that will be on California's ballot to repeal Proposition 209, which banned affirmative action. Do you think we should now, especially in the light of what's happened after George Floyd's death, use race as a consideration when determining who gets admitted to colleges?
I think it should be a consideration. You know, at the University of California, our admissions officers review a student according to 14 different criteria. They want to evaluate the whole student. They want to evaluate how the student would contribute to the university should they be admitted. The only thing they can't look to is the student's race, gender, or ethnicity, which is a key part of a student's identity. It's such an artificial limitation. So I hope that the ban on using those factors is repealed by the California voters in November.